So I can start. Good morning. Mary?
Hazel?
Yes.
Yes, okay.
Hello. Okay, thank you. Gosh, I do love these Zoom sessions where you know, in the old days, somebody would nod their head at you and you'd stand up and say, welcome everybody. Here we have to check that everything's working. And I'm glad that it is. And I'd just like to quickly introduce myself and welcome all of you. My name is Adrian Bellinger. It's written there on the screen. I'm the acting dean in the School of Law at the University of KwaZulu-Natal. And it gives me great pleasure to, on behalf of UKZN, to welcome everybody today. I'll get into all the bits and pieces and the details, but the African Ombudsman Research Centre and the UKZN School of Law have a very, very, very close and I think a very important and valuable relationship. And having recently stepped into the role of acting dean, this is the first time I'm having an opportunity to interact in this forum, and I must say I'm delighted. And contrary to the norm these days, I've volunteered to take on this position and to do this welcome because I was looking forward to meeting everybody and seeing all of you. I just would like to welcome everybody who's attending the seminar and the webinar, I should say, because of out of interest, but also specifically to welcome to the people who will be participating today. I think that we've got a range. I'm sure that I'm going to make a real hash of people's surnames, so please forgive me in advance. But firstly, to Advocate Gatlelo, who's the acting public protector, it's quite nice to have somebody else who's acting alongside my acting role. So I'm doubly pleased to have you here, well, when she joins us. We have a facilitator. Now, I know the facilitators have the hardest job of all and tend to get sort of welcomed as an afterthought, but I'm going to just upfront say, Mrs. Mohaiwe, the Deputy Inspector General in the government in charge of ombudsman function in the Inspectorate of Government Uganda. Wow, that's a long mouthful. I'm delighted that you're here and thank you for facilitating this. I'm sure that you're going to have a very busy morning. Our first speaker is the Honourable Justice Chizumila, who is the Judge of the African Court on Human and People's Rights and a former Ombudsman in Malawi, so welcome. Our second speaker is the Honourable Fatimata Sanu, who's a mediator du Faso, the Ombudsman for Burkina Faso, welcome. And our third speaker is Ms. Pierre, Director, Special Ombudsman Research Team, the Ombudsman of Ontario in Canada. So welcome to all of you. Just a quick word before I hand over to my acting colleague, is that in my sort of history in the law school, in my position from an academic point of view is that I teach the law of evidence and I teach some of the procedural courses. And I think I'm the only person left who teaches entirely adjectival law. And so as a result of that, evidence, fact-finding, investigation, the collation of evidence and that kind of thing is very, very close to my heart. In fact, it's mostly what I research and write on. So it's another reason why I volunteered to do the welcome today. And that is, it's an incredibly important part of every single thing that everybody does the moment you try and in any way look into the protection of people's rights, or in order to achieve that it's a lofty term, but it's a genuine one, try and achieve justice for people. The law school recently hosted a lecture that is one of a lecture series over the years, which is named in memory of two graduates of the university who were brutally murdered by the apartheid era hit squad police. And when talking to the guest, the audience there, we were looking at the fact that in this modern day and age, we have not left behind some of those legacies. And it's not just in this country, but it's around the world, where extrajudicial killings and that kind of thing are still very much a part of our lives. And what struck me with last week's sort of the talk we had last week was that you cannot achieve justice. You cannot achieve any sort of any uncovering of the sores of the past or any justice in respect to things that occur in the present without a proper dedicated investigation that uncovers evidence that's presentable or that can be utilized. And so people tend to overlook that it's the nitty-gritty background that actually determines whether there's going to be any success at a high profile or even at an ordinary level in the future. And so I think that effective investigation strategies, building blocks, methods and tools which is the topic of today's seminar, is absolutely, it's an imperative foundation for anything that you take forward going, if you hope to achieve anything, which as a procedural and adjectival lawyer, and as you guys as ombudsman, we're on the same page. It's about protecting the public. It's about protecting people's rights. It's about trying to find justice. And I said, you cannot undo that if you haven't done the background and the homework. So I'm delighted that this is what the seminar is about. I think it's a very, very valuable topic. And all I can say is enjoy the morning. It's going to be educative and informative. I'm certainly going to be listening in as the morning unfolds. So thank you very, very much indeed. And welcome on behalf of the UKZN School of Law to today. Thank you.
I think we're having a bit of a problem with the Deputy Public Protector joining. So David, I think you can continue until she actually joins to give her a welcome. I see Frankie's just come off the phone, so maybe he's been having a chat with her.
I'm reluctant to say anything further because I would then be acting for somebody who's acting, so we'd be acting. So perhaps we just give her a moment to see if she can join.
David is the facilitator, so David can continue. He's acting on behalf of Mrs. Murewe. She was called to Parliament urgently. So David can continue with the facilitation duties until we get the Deputy Public Protector in.
Okay, thank you very much.
Thank you, David.
Yes, I hope that everybody can hear me clearly. I thank you and I bring you greetings from the Inspectorate of Government in Uganda. My boss, the Deputy Inspector General of Government, sends her regrets. Mrs. Mohaire was supposed to be facilitating this session, but she had to be, she was urgently called away to attend to some state duties. And I will be sitting in for her in the role of facilitator. My name is David Makumbi, and I am the Director responsible for Ombudsman Affairs at the Inspectorate of Government. I'm very pleased to be facilitating this webinar on the very apt topic about effective investigation strategies and the building blocks, methods, and tools that go with the effective investigation strategies. We have three very eminent speakers that will be addressing us on this subject, and I believe our first speaker is the Honorable Lady Justice Tujilane Rose Chizumila, who is a national of Malawi and was elected judge of the African Court.
David,
yes,
David,
yes,
sorry
yes,
to interrupt. The Deputy Public Protector is here, but actually she's waiting to be allowed to speak. And we are just trying to upgrade her to the panelist. So if you can just give us a minute, she's logging out and she'll try to join in again. Sorry about that.
No problem. I'll wait for you to clear me.
Yeah, please just bear with us. Give us a minute. It's not that she was not here. She was here from the very beginning, but we are technically struggling to upgrade it to a panelist. Okay, I'm waiting for her to join again. Just bear with us for 1 minute. Repeat.
Recording in progress.
Very good morning. My sincerest apology. The link I had didn't allow me to speak. May I kindly continue, Program Director?
Yes, go ahead. Thank you.
Thank you. A very good morning, Madam Facilitator, Ms. N. Twani Mungisha Muharrem, Judge of the African Court on Human and People's Rights, Honorable Justice Tujilane Chizumila, Mediator of Burkina Faso, Honorable Fatima Senotor, Director, Special Ombudsman Response Team, Ombudsman of Ontario, Canada, Ms. Domani PM, Academic Leader for Teaching and Learning at the UKZN School of Law, Dr. Freddy Nyongani, the Acting Dean, Andre Belenguer. I'm sorry, Acting Dean, maybe just like you have done injustice to the names. I apologize, colleagues, distinguished guests, other colleagues present on the platform, ladies and gentlemen. I bring you the warmest of greetings from South Africa in Pretoria on this wonderful day where we'll be exquisitely discussing and interacting on effective investigation strategies. As we all know, this is quite a pertinent issue, especially at this time in our continent and in the world, with all the developments that are happening, especially around mandates where we do investigations in state affairs. I also wish to take this moment to thank all of you for having availed yourself to participate in this critical webinar. Once again, we meet on this virtual platform under the banner of the African Ombudsman and Mediators Association, known as AOMA, to exchange ideas, trade good practices, benchmark, and essentially learn from one another. This session presents an invaluable opportunity for every one of us to hone their skills so as to always stay ahead of the curve on matters critical and central to the work of the ombudsman and mediators. We should all leave the session equipped with the necessary know-how to be in a position to more effectively assist the public we exist to serve, vindicate their rights, while exacting accountability on public administrations in our respective countries. As you may be aware, capacity building, along with research, information sharing, and advocacy, is at the core of the strategic work of our host today, AORC, which is AOMA's heartbeat. Over the last 2 years, during which business all over the globe was severely disrupted as the world fended off the effects of the universal outbreak of the COVID-19 pandemic, the AORC ensured continuity through these non-contact training sessions, and for that we remain grateful. In fact, in the 2-year period from early 2020 to date, the AORC has held up to 20 informative webinars. I am informed that this hard work has not gone unnoticed as global colleagues commended the center on the sidelines of the recent annual board meeting of the International Ombudsman Institute in New York. With today's session, we continue in this path of capacity building, enhancing skills, strengthening our organization. This time around, the focus is of particular importance as it goes to the heart of the purpose of our existence as ombudsmen and mediators. It seeks to explore the strategies that we ought to employ for effective investigations. As a former prosecutor, I know how important investigations are, because before any further action can be taken, an effective investigation must have given a guide. And as the world advances in terms of its maladministrations and malfeasance, we too need to advance our skills in investigations to curb and combat these malfeasance in state affairs. Like many others before, this subject matter ranks amongst the leading training needs for the AOMA membership, as identified through the IORC's needs assessment in respect of capacity building priorities. According to the Secretariat of the Treasury Board of Canada, an administrative investigation refers to, I quote, an inquiry into or examination of the circumstances surrounding a situation, incident, event, occurrence, issue, matter, complaint, etc., in order to determine all relevant facts and establish a documented basis upon which a decision can be taken, I unquote. Complainants place a lot of trust in our hands as ombudsmen and mediators, hoping that when all is said and done, we will take them as close as possible to where they were or would have been had it not been for the maladministration they alleged and experienced. In the same vein, respondents such as public institutions and functionaries trust us to carry out lawful, independent, impartial, rational, reasonable, and even-handed investigation so as to arrive at a just and fair decision and remedies. But as you would know with investigation, it is not always a smooth sailing. Challenges abound. These include undue delays, non-responsiveness, uncooperative conduct, destruction of evidence, and frustration of investigation through court challenges on the part of respondents, unreliable information, unavailability of information, impatient complainants, but also a shortage of skill set on our side, etc. In the premises, there are several steps that may form part of the building blocks of an ombudsman or a mediator's investigative process. They include, as I just rushed through them and are not limited to the following: planning, information and evidence gathering, assessment of evidence, applying the appropriate standard of proof, determining the state of allegations. In South Africa, beyond the Constitution and the law, the Ombudsman, known as the Public Protector, relies on two main authorities, known as the Malian Guardian versus the Public Protector, and the Economic Freedom Fighters versus the Speaker of the National Assembly. These have been landmark cases which have developed our jurisprudence as an ombudsman beyond our constitutional and legislative mandate. We found in these seminal rulings by the Supreme Court of the Appeal, as well as the Constitutional Court, respectively, a lot of wisdom which we have worked into our investigative processes as we too embark on ensuring effectiveness and impactfulness of our mandate. Let us take the Malian Guardian versus the Public Protector case, which is very much relevant in our theme today. For example, in that decision, the Supreme Court of Appeal held that, I quote, "The Ombudsman is not a passive adjudicator between citizens and the state, relying upon evidence that is placed before him or her before acting. His or her mandate is an investigatory one, requiring proaction in appropriate circumstances." I unquote. It further goes on to say that the powers of the Ombudsman emphasize once again that he or she has a proactive function. He or she is expected not to sit back and wait for proof where there are allegations of malfeasance, but is enjoined to actively discover the truth. Elsewhere, the judgment further states that the Ombudsman must not only discover the truth, but must also inspire confidence that the truth has been discovered. Perhaps most importantly, the judgment reminds us that an investigation must be conducted with an open and inquiring mind, explaining that any investigation that is not approached in that manner is no investigation at all. It explained further in the judgment, I quote, an open and inquiring mind is one that is open to all possibilities and reflects upon whether the truth has been told. It is not one that is unduly suspicious, but it is also not one that is unduly believing. It asks whether the pieces that have been presented fit into place. If at first they do not, then it asks questions and seeks out information until they do. It is also not a state of mind that remains static. If the pieces remain out of place after further inquiry, then it might progress to being a suspicious mind. And if the pieces still do not fit, and then it might progress to conviction that there is deceit. How it progresses will vary the exigencies of the particular case. One question might lead to another, and that question to yet another. And so it might go on and on, I unquote. These extracts places under the spotlight the considerations that ought to underpin an investigation as a fact-finding mission in a quest to find the truth with the aim of resolving disputes between states and members of the public. The role of the ombudsman and mediators remain at the core of the contribution that these institutions could potentially make towards the realization of Africa's 50-year development plan, Agenda 2063, the Africa we want. This plan seeks to bring about the Africa envisaged by the founders of the African Union's forebear, the Organization of African Unity 59 years ago in Addis Ababa. I am reminded of the words of Professor Lumumba when he delivered his speech in the BMH conference a few weeks ago in Cape Town, South Africa, where we said, I quote, leaders and politicians think of elections or think as far as elections, whereas it should be as far as generations to come. I end quote, ours as mediators is then to shape the work of government and strengthen our democracies as leaders in our sectors for generations to come. Underpinned by 7 aspirations, the plan in this continent's strategic framework for inclusive and sustainable development to be realized just over 40 years from now. Aspirations 3 and 4 thereof, which are about good governance, democracy, respect for human rights, justice and the rule of law, as well as peace and security, are the most relevant to us as the ombudsmen and mediators in South Africa. I therefore look forward to hearing from our esteemed colleagues, the Honorable Justice Chizumila and Honorable Tur and Ms. Pierre. Above all, I look forward to the engagements that will follow their contributions that will from today on help to shape our mandates progressively. I thank you.
Thank you very much, Madam Deputy Public Protector, for your introduction and your very apt explanation of this topic, of the urgency and the importance of the topic that is set before us, because indeed investigations are actually the bedrock that form the basis for any findings that any ombudsman office is going to put out in order to be able to guide the different public institutions that are dependent on the ombudsman function. Without further ado, I will just quickly reintroduce myself. My name is David Makumbi. I am a Director for Ombudsman Affairs at the Inspectorate of Government. I'm sitting in for the Deputy Inspector General of Government, Mrs. Anne Muhaire, who is unable to be with us due to some urgent state duties that came up just today. And I'll be facilitating this session. Now, by way of the housekeeping, we will have presentations from three panelists, and each presentation will take 15 minutes. After the presentations, we shall have a question and answer session, which question and answer session will go on for about 25 minutes. We'll try to accommodate as many of the questions as are raised as possible, but if any questions are not answered during that period, please, your questions will still be taken on by the African Ombudsman Research Center, and they will be addressed to the panelists who will respond to them, and the AORC will be able to provide the responses in due course. I welcome you once again to this session, and we shall now go on to the first panelist. Our first panelist will be Honorable Justice Tujilane Rose Chizumila, Judge of the African Court on Human and People's Rights and former Ombudsman of Malawi. Justice Tujilane was elected to the African Court on Human and People's Rights in January 2017 during the 28th Assembly of the Heads of State and Government of the African Union for a 6-year term. She holds a master's degree in international law and has held several positions in the judicial, legal, academic, diplomatic, governance, and corporate fields in Malawi, including Judge of the High Court of Malawi, State Advocate and Legal Aid Advocate with the Ministry of Justice, and Secretary to the Law Society of Malawi, first female Ombudsman, Malawi High Commissioner to Zimbabwe, and proprietor and founder of Chizimula and Company Advocates. She has a number of publications to her credit, and including A Widow's Perspective, a personal experience, a publication which led to the enactment of a law in Parliament making property grabbing an offense in Malawi. We welcome you, Honorable Justice, and the Honorable Justice will be doing a presentation on effective investigation techniques. Honorable Justice, you're welcome, and the floor is yours. Thank you.
Thank you so much, Mr. Presenter. And I will greet Mr. Adrian Berengere, Acting Dean, School of Law of the University of KwaZulu-Natal, Advocate Koleka Ngaleka, forgive me, I cannot pronounce your surname properly, Acting Public Protector of South Africa, and the Acting Chairperson of the AORC Board. And all other honorable ombudsmen who are present today, fellow speakers, and I should not forget our hosts, the African Ombudsman Research Center. My presentation today is on effective investigation techniques. I listened with keen interest to the brief presentations given by Mr. Adrian Berengere and our Acting Public Protector of South Africa. Indeed, evidence is so crucial. And I'm now speaking as someone sitting on both the national bench and the international bench of the African Court. When evidence is not sufficient, then you lose a very good case on behalf of your clients. And we are talking about human rights of your clients, of the citizens at the end of the day. So what are effective investigations? These are requirements to get the evidence needed to make findings in relation to the matter. It is the core, at the core of conducting effective investigations. It is an art that needs to be consistently practice to get the best results from your interviews. It gives you good quality, detail-rich data from witnesses and maintains procedural fairness and develops rapport. Investigators, when it comes to effective investigations, should always take a back seat because it is the witness who is the expert on the evidence they are given. Different ombudsman offices have got specific investigation processes to follow. For example, the Ombudsman Act of Malawi. There are several steps on effective investigations, and I will just briefly run through them. I've picked the general ones. First of all, the compliance with existing policies and procedures concerning investigations is very crucial. Again, to ensure procedural fairness throughout the process. A sound investigative process will also ensure the finality of outcome, leaving no room for doubt in case also the matter goes to court. Complainants, witnesses, and employers understandably desire a process where finality and clarity are achieved. Who is involved in this process and what are their roles? Briefly, we have the witness, and as an investigator, you need to explain the whole process of investigation, what your role is as an investigator, the role of the witness and any support person. Explain to them that they are the experts who are giving evidence before you. Explain what will happen at the interview, how the interview will be recorded and how the witness will get a copy of the record of interview. In other words, explain the whole process up to the end. Then we have the investigator who conducts the interview. And then you let the witness tell their story. You should not give your opinion on the matter being investigated as an investigator. And you should also ensure you do not allow anyone else, for example, a support person, to attempt to answer questions on behalf of the witness. There is the support person also, and make it clear to the support person that they are not to advocate or represent the witness in the interview. This is crucial because at times, like when I was ombudsman, a support person would try to respond on behalf of the witness, or the witness would actually ask the support person to come in and help him in giving responses. That should not be. The other party is the respondent. And the respondent, you should ensure as an investigator, has access to the allegations against them prior to the interview. Then finally, you need to have a participant's guide, which will take you through the process. It will assist you to set out the whole interview process. Having said that, there are several steps that one needs to take in this investigative process. I will just jump through them because I know my fellow speakers will touch on these and go into details. There is the step of receiving a complaint. Immediately you receive a complaint, you have to conduct prompt and effective investigation, follow internal policies and procedures. Again, find out if there is need to take any steps, immediate steps, to stop alleged conflict, illegal actions and behaviors, in order to protect involved parties, you might need to provide interim protection to continue, to guard against continued harassment or retaliation by either transferring a person or giving them leave of absence or scheduling a change in the process of the investigations. Employers are advised to seek legal advice prior to making any decisions on this
إجازة عن
issue.
العمل أو القيام بأي من الأمور الأخرى.
Hello, excuse me. Hello?
No, carry on, Justice. I think there was the interpreter. Yes.
All right. The benefits for this is that you can easily identify and resolve internal problems before they become widespread, and you ensure everyone's protection. Again, we go back to the issue of in case the matter goes before a court of law. The other step is letters of notification and allegation. These are very crucial. The letter of notification describes what is being investigated, who the investigator is, the right to request an interview support person, and the need to maintain confidentiality. Likewise, the letter of allegations provides a clear description of the complaints that have been made against the respondent, and particulars of allegations, any request for supporting documents, option of a support person's presence, and confidentiality, and other issues which are very crucial for a respondent to know in advance. The correspondence within the investigation should be very clear, comprehensive, and accessible by the relevant parties. Again, the issue of confidentiality is another step and has to be protected, but with caution. We are advised not to inform parties that everything will have confidentiality. We should explain that information might be shared if there is need, only on a need to know basis. Another step is the selection of the investigator. The qualities of an investigator to start with are very crucial. One needs to have an ability to investigate objectively without bias, prior investigative knowledge and working knowledge of employment laws. They should have no personal relationship with the parties involved. The interpersonal skills to build a rapport is very crucial because these are the ones meeting the claimant and all the other parties and talking to them to ensure that the matter ends in a fair and neutral condition. They must have attention to detail. The right temperament to conduct interviews is very crucial. I do not need to emphasize on this. You know, when you are handling these cases in offices of the Ombudsman, you meet assorted types of people, of complainants, of respondents with assorted moods, and at times it is easy to lose your temper. So it's very crucial to have the right temperament, be able to maintain confidentiality and be respected within the organization, and also in your own employment if you are internal candidate, an internal investigator. Who can be selected as an investigator? Generally, there are different resources that are used by the employers for certain ombudsman offices, like the Ombudsman of Malawi. We have specific officers appointed for this job, but there are other offices where the employer might need to use experienced human resources professionals, internal security, legal counsel, both inside and outside the organization, a third-party investigator, or a team approach. All these have distinct advantages and disadvantages. You can read that in my presentation later on. You need also to create an interview framework plan for the investigation. This is a very useful tool for running the interview process appropriately. Remember, the interview process is very crucial for the rest of the investigative process. So it must be planned effectively and properly executed. An example of a plan should include at least an outline of the issue, the development of witness lists, development of questions, sources for information and evidence, process of retention of documents, all of that, the number of days you will spend for the interviews and the amount of time. Again, always ensure you've already arranged a secluded conference. How much time are you giving between the interviews, and give yourself time between the interviews to fill in the details and to adjust new information, evidence or witness. Always keep the investigation flowing efficiently. At the beginning of this webinar, this issue of keeping this webinar flowing was also mentioned. It's very crucial. You should review and assess credibility of the witnesses and all the the respondents, etc., who are appearing before you. And then you discuss a proposed recommendation, decide on the final resolution, then create relevant disciplinary actions, which will now be done by the employer, warnings or memos, and you finally write your investigation report. I want to emphasize the use.
Honorable Justice, just to alert you
Yes.
that you have a couple of minutes left.
Thank you.
About 2
Thank you.
minutes left.
I'm almost done. I'm almost done. Thank you. I want to emphasize the use of questions. Good questions are relevant and designed to draw out facts without leaving out the interviewee. And you should use a mixture of questions in order to get that rich quality data needed from the investigation. They are encouraging narrative questions where the interviewer asks witness to narrate the evidence in an uninterrupted way. This encourages them to recall the events without being interrupted. And then we have open-ended questions, which are more likely to get you more richly detailed and more accurate evidence. Closed questions such as who, what, where, when, how are useful for clarifying the evidence collected in the narrative. And then you have direct questions. Always maintain neutrality. Let me emphasize that the point of listening is very, very crucial. Listen closely, and as you listen, you might pick something that you had lost out before. Also, body language, be careful, always look at the body language of whosoever you are investigating and you are interviewing. It's very crucial. And finally, you need to have a rapport, to build a rapport. This is very, very crucial. And this rapport enables an interviewee to feel comfortable and more relaxed. Don't just jump straight into your investigation questions. at least welcome them, tell them where to find the bathrooms, offer them a cup of coffee, a glass of water, ask them how their trip to your office was, things like that. And then you now open up the investigation interview. After you make the findings, make sure that you inform both parties. This is very, very crucial. I recall that at the office of the Ombudsman in Malawi, after the findings are made, parties are given a period, a space of time to come back in case they are not satisfied with the findings. I will now go, that is, I think, what I had, but I want to emphasize finally on the issue of document control. And this is really crucial. All records of investigation should be kept under lock and key in a limited access area. Do not leave documents accessible or in plain view, and avoid using original documents. You should at least place them in a secure file, and all interviews should be used with copies. This is very crucial in order to avoid the original documents getting lost and information getting to the public before the matter is finalized. The control and the tracking of cases is has the same importance as keeping documents under control. Finally, in conclusion, we see that the lack of proper conduct of investigations may lead to avoidable mistakes that may compromise the investigation and in some instances aggravate circumstances. It is therefore crucial to have guidelines for investigative strategies, and in addition, consider having a training program on the proper methods of conducting an investigation for all compliance officers, human resources officers, security officers, internal audit, legal counsel, and all those involved in your investigations. I thank you for listening.
Thank you. Thank you very much, Honorable Justice, for that extremely enlightening presentation on effective investigation techniques. You have raised quite a few important highlights with regard to investigation, but I believe one of the things that has struck me most is that when we are doing the investigations, we need to be mindful of what kind of outcome we are pursuing. And to that extent, the collection of the evidence must suit the kind of outcome that we expect. If it is a matter which is going to court, for example, there are certain things that must be taken into account by the investigator. And an investigator should not, for example, investigate without considering that later on the evidence that's to be relied on is also going to be utilized in court. So the investigator must also be mindful that this evidence is going to be used at a later stage. And to that extent, certain things must be done very carefully to ensure that this evidence at the end of the day supports the findings of the court or supports the findings of the Ombudsman office, even in administrative interventions that the Ombudsman office may do. So we thank you very much for that presentation. I realize that it was really a short period of time that you were given, but we did get quite a bit of information from that presentation. And we look forward to looking at the paper in its full detail. For the members that are following, I'd like to remind you that there is a question and answer button at the top of your screens where you should direct your questions. Your questions will be collected and they will be directed to the presenters once all the presentations are done, and we will do our best to accommodate all the questions. Thank you once again, Honorable Justice, for the presentation. We are now going to have another presentation coming in from Honorable Fatimata Sanu, the Honorable Ombudsman of Burkina Faso, who will discuss organizing and managing investigations and learning from the investigations. Honorable Fatimata.
Frankie, allô, nous sommes là. Oui. Est-ce que vous m'entendez?
On fait encore l'introduction. On va vous donner la place pour
merci
parler.
pour la parole.
On fait encore l'introduction. On fait encore l'introduction. On va vous donner la parole tout à l'heure là.
D'accord, OK.
1 minute. Yeah.
Okay, thank you very much, Frankie, for that clarification. Honorable Fatimata was promoted to the position of mediator of Burkina Faso on 26 November 2021. She is committed to consolidating the institution's achievements and strengthening visibility of the institution at regional, international, and other levels. In this capacity, she holds the position of Secretary General of the Association of Mediators of the region in which her country falls. She's a magistrate committed to the defense of citizens' rights and the promotion of sexual and reproductive health and family planning. She has successively held the positions of senior investigating judge with the rank of Vice President of the High Court of Ouagadougou, President of the High Court of Ouagadougou, and President of the Chamber at the Court of Appeal of Ouagadougou. She has a specialization in law of development at the International Organization of Development Law, or IDD, in Italy. And she has become known over the years through her active representation of organizations and in the defense of and promotion of human rights. Honorable Fatimata is going to be discussing organizing and managing investigations and learning from investigations. Honorable Fatimata, the floor is yours. Thank you very much.
Oui, merci pour la parole. Nous sommes très contents ce matin d'être en contact avec vous pour parler du thème sur les stratégies d'enquête. Ce qu'il faut dire, c'est que le bureau du Burkina Faso est en Afrique de l'Ouest et nous avons été nommés médiateurs en 2021, si je peux le dire ainsi. Le thème qui nous a été confié est vraiment d'importance parce qu'il est le cœur du métier de l'ombudsman. Nous sommes créés pour ce métier, pour instruire les plaintes qui nous sont confiées. Et donc, c'est très important que nous ayons des lignes directrices pour mener les enquêtes. Je vais rentrer directement dans le vif du sujet en disant qu'en ce qui nous concerne, le médiateur du Faso est compétent dans des matières relatives à la carrière de l'agent, aux finances, aux marchés publics, aux avantages vieillesse, aux questions foncières et aux conflits communautaires. Il y a aussi les crises sectorielles et la justice, la crise de la justice. Donc, lorsque le médiateur est saisi d'une plainte, il faut dire que l'élément déclencheur se trouve dans la loi fondamentale parce que nous sommes inscrits dans la Constitution. Et donc, il s'agit pour un citoyen ou bien pour un élu ou bien pour le président du Faso de saisir le médiateur pour lui demander de mener une enquête dans un domaine qui le concerne. Il y a aussi le fait que le médiateur peut se saisir lui-même de toute question qu'il juge causer préjudice à l'intérêt général. En ce moment, c'est lui qui prend l'initiative de la de l'investigation et alors il met en œuvre les éléments que je vais vous présenter maintenant. Donc, lorsqu'il reçoit la plainte, il doit d'abord vérifier la recevabilité de la plainte. Est-ce que la plainte est écrite? S'agit-il d'une personne physique ou morale? Est-ce que les démarches préalables ont été effectuées? Est-ce que l'administration a refusé de faire droit à la requête du réclamant? En d'autres termes, il faut qu'il vérifie en la forme si tous ces éléments-là sont remplis. Ensuite, au fond, il faut que le médiateur vérifie si la plainte entre dans son domaine de compétence. Parce qu'il ne faut pas oublier que les affaires privées, les affaires politiques et l'immixtion dans les procédures judiciaires ne peuvent pas être connues par le médiateur du FASO. Donc, au fond, le médiateur vérifie quels sont les griefs qui sont articulés, quelles sont les attentes formulées dans la requête, quelles sont les administrations mises en cause ou quelles sont celles qui sont concernées par les griefs. Donc, voilà déjà la démarche préliminaire, la recevabilité de la plainte en la forme et au fond. Parce qu'il ne faut pas oublier que nous nous adressons généralement à des administrations et la procédure telle qu'elle est mise en œuvre voudrait qu'elle soit écrite. C'est déjà le principe de l'écrit qu'il faut relever. Et l'écrit est matérialisé par l'obligation de formaliser les échanges entre le médiateur du FASO et l'administration mise en cause ou entre les plaignants aussi. Toutefois, il faut remarquer qu'il y a des moments où l'écrit ne peut pas être immédiat compte tenu de l'urgence d'une situation. En ce moment, pour éviter des préjudices éminents ou lourds de conséquences, le médiateur peut directement procéder à une enquête en écoutant les témoins, en écoutant les répondants, en les auditionnant, en faisant des entretiens, en expliquant le processus, en créant un cadre d'interview, en ayant un bon questionnaire avec des questions ouvertes ou fermées. Mais il faut relever que le médiateur doit laisser les témoins s'exprimer. Ça, c'est dans les cas d'urgence, les cas où le médiateur n'a pas le temps d'écrire une correspondance. Ensuite, nous voulons relever que nous adressons des accusés de réception automatisés aux réclamants. Pourquoi nous avons institué cette pratique? Parce que tout simplement, lorsque le médiateur reçoit la plainte, il a généralement affaire à un citoyen qui est vraiment dans le désarroi. Il n'a pas pu obtenir, ce citoyen n'a pas pu donc obtenir de l'administration réparation de ce qu'il réclame. Et le médiateur a l'obligation de le rassurer dès qu'il reçoit sa plainte que son dossier sera traité. Donc, il y a aussi le principe du respect du contradictoire qui permet une instruction à charge et à décharge sous forme de réunion et de concertation avec l'administration. Et après le contradictoire, nous pouvons parler du respect des délais. Il s'agit ici de se fixer des délais pour se procurer tous les textes de loi pertinents ou toutes les politiques publiques qui seraient utiles. Par contre, pour les décisions de justice définitives, il faut que le médiateur fasse des injonctions à l'administration et lui fixer des délais à respecter. Quels sont maintenant les outils utilisés pour pouvoir mener à bien cette investigation? Le médiateur dispose du droit d'accès à l'information, du droit de convoquer les agents publics, du droit de demander aux autorités administratives de faciliter les missions, le droit de demander au ministre de lui communiquer tout dossier ou tout document concernant une affaire à propos de laquelle il fait son enquête, sauf en cas de défense nationale, de sûreté de l'État ou de politique extérieure. Donc, voilà un peu les outils dont dispose le médiateur dans le cadre de son investigation. Ça lui permettra donc de s'approprier véritablement des éléments du dossier et maintenant de se faire une idée précise sur la nature de la plainte, de déterminer les attentes du demandeur de façon précise, d'apprécier les éléments de fait et de droit tels que le dossier permet de les appréhender, de rechercher toutes les pièces utiles et pertinentes propres à établir le bien fondé ou non des griefs articulés, de vérifier la matérialité et l'irréfutabilité des faits, de répertorier des éléments convaincants sur le bien fondé ou non en droit ou en équité de la prétention et au besoin de procéder à une reformulation. Maintenant, il faut dire qu'après avoir utilisé tous ces moyens, lorsque le médiateur se trouve encore confronté à une obstruction, parce qu'il faut le dire, il y a des parties qui ne sont pas de bonne foi et qui font tout pour bloquer le processus de l'investigation. En ce moment, le médiateur est autorisé à demander l'intervention des inspections, des services techniques et de tous les corps de contrôle de l'État. C'est un outil puissant qui permet à tous les corps de contrôle de l'État de répondre à la demande du médiateur pour l'aider à investiguer. Et c'est l'article de la loi fondamentale qui lui donne ce pouvoir. Et ce qu'il faut noter, c'est que l'intervention de ces corps de contrôle intervient en cas d'une complexité de l'affaire ou en cas de volonté manifeste et obstinée des administrations concernées de faire obstruction à la manifestation de la vérité. Donc, il faut dire que la combinaison de plusieurs pouvoirs du médiateur peut s'avérer utile au cours de l'instruction d'une même plainte. Et maintenant, parvenu au terme de l'investigation, le médiateur a des solutions à proposer. D'abord, il va informer le plaignant que les investigations n'ont rien révélé d'anormal et que les textes lui ont été justement appliqués. Deuxièmement, le médiateur pourra faire des recommandations visant à le rétablir dans ses droits s'il est fondé. Donc, après les résultats, les conclusions de l'enquête. Troisièmement, le médiateur pourra faire des propositions de réforme tendant à l'amélioration du service et tout cela dans un délai qu'il va fixer. En guise de mesures complémentaires, le médiateur peut en aviser le président du FASO par écrit dans un rapport spécial en cas de mesures insatisfaisantes prises par l'administration. Et le médiateur peut attirer l'attention du président et de l'Assemblée nationale sur les réformes législatives, administratives et réglementaires envisagées qu'il juge conformes à l'intérêt général, notamment dans les plaintes récurrentes systémiques qui concernent un très grand nombre de personnes. Maintenant, qu'est-ce que nous pouvons dire comme leçon que nous pouvons retenir? Il y a près de 3 décennies que le médiateur du FASO est installé dans le Burkina Faso et nous pouvons retenir certains aspects qui sont essentiels pour le bon fonctionnement et la bonne investigation dans les bureaux de médiateurs. Il faut d'abord que l'indépendance du médiateur soit affirmée. Si le médiateur n'est pas indépendant, il ne pourra pas mener ses investigations de façon sereine, de façon administrative et professionnelle. Il faut dire que le médiateur, dans l'exercice de ses fonctions, ne doit recevoir d'instruction d'aucune autorité. Et donc, cette indépendance, elle est confortée par la prestation de son serment, le caractère non renouvelable de son mandat, l'irrévocabilité de son mandat, son immunité juridictionnelle, parce que dans le cas de son investigation, il ne peut pas être poursuivi. Mais son mandat doit être incompatible avec tout autre mandat notamment politiques. Et il faut que le médiateur soit indépendant sur le plan budgétaire. Le deuxième aspect que nous estimons important, c'est l'écoute. Il faut d'abord que le médiateur puisse écouter les plaignants parce que cela est important. Toute prise de contact, toute écoute apporte un apaisement pour le plaignant et c'est d'une grande portée sur le plan moral et psychologique. L'écoute apaise, l'écoute permet à l'instruction de disposer d'éléments de grande valeur pour cerner tous les aspects de l'affaire. L'écoute est d'une grande efficacité parce qu'elle réhabilite la foi en l'État dont l'image a été écornée à un moment. Et nous recommandons à toutes les administrations et à tous nos grands services africains de se revêtir d'un peu plus d'humanisme parce qu'elles doivent être soucieuses du respect du droit des citoyens, des usagers. Ensuite, il y a le professionnalisme des enquêteurs dont on parlait tout à l'heure. Les enquêteurs doivent être bien outillés, ils doivent avoir une excellente formation. Leur expertise doit être riche et variée dans tous les domaines de l'administration, comme je le mentionnais ci-dessus. Lorsque une plainte arrive au niveau du médiateur, il doit être en mesure de la prendre en charge parce qu'il a l'expertise. Et ses capacités doivent être renforcées de façon périodique pour faire preuve d'encore plus de professionnalisme et de diligence. Il faut noter aussi que les pouvoirs du médiateur, ce dont on parlait il y a un instant, c'est-à-dire le droit d'accès à l'information, de convoquer les agents, de demander aux autorités, de convoquer les ministres ou même de demander l'intervention de tous les corps de contrôle de l'État, tous ces pouvoirs doivent être utilisés quand même avec sagesse et responsabilité pour ne pas créer une atmosphère inquisitoire ou suspicieuse. Le juge, lui, il l'inquisitionne, alors que le médiateur, lui, doit s'obliger à expliquer de façon pédagogique, douce, limpide, motivée et structurée, dans un langage accessible à tous, en quoi une plainte, après avoir été instruite, est fondée ou n'est pas fondée sur le plan du droit ou de l'équité. Il faut aussi, selon nous, un autre aspect important, que l'institution du médiateur soit accessible à tous les citoyens. C'est pour nous l'occasion de parler de la déconcentration des services dans les régions et de recommander aux autres bureaux de tout faire pour pouvoir en avoir afin de couvrir le territoire. Et parlant des moyens d'action du médiateur du FASO, il est important de doter l'organe de médiation institutionnelle de larges pouvoirs, de larges prérogatives d'investigation, ainsi que de moyens conséquents pour faire face à toutes les difficultés qui pourraient survenir dans le cadre de l'instruction. Du reste, concernant la zone Afrique de l'Ouest, les médiateurs ont fait le constat que bien qu'exerçant leurs fonctions dans le même espace sous-régional, les prérogatives et les moyens d'action des uns et des autres divergeaient d'un pays à l'autre. Aussi, lors de leur toute récente 6e Assemblée générale ordinaire, les médiateurs de l'UOMOA ont adressé à l'organe suprême de la conférence, c'est-à-dire la conférence des chefs d'État, une demande pour harmoniser leurs attributions et leurs compétences, en tenant naturellement compte des standards continentaux, internationaux en la matière, afin de donner une meilleure efficacité à leurs actions respectives. Cette vision pourrait amener les dirigeants de l'espace à accorder davantage de moyens aux institutions de médiation au regard de la spécificité des ressources de chaque pays. Permettez-moi maintenant de conclure sur l'éthique du médiateur pour mener à bien les investigations. Le médiateur doit veiller à sa conduite personnelle, à son intégrité, à son impartialité, au sens de sa responsabilité, à sa loyauté, à sa confidentialité, parce que toutes les preuves qu'il va recevoir, tous les éléments sont considérés comme sous le sceau de la confidentialité et surtout au risque de conflits d'intérêts. Voilà ce que le bureau du médiateur apportait comme humble contribution à la thématique de ce jour. Nous vous disons merci de nous avoir invités et nous sommes à l'écoute des questions. Merci.
Thank you very much for that presentation, Honorable Fatimata. It was indeed quite enlightening with regards to how the mediators approach their work. And we've had the opportunity to hear from you concerning some of the key aspects in terms of organizing and managing investigations, such as the need to keep in mind the restrictions that may be prevailing over any given matter, such as the fact that maybe a matter that has been brought before you might be also in court, in which case you cannot intervene. These are all very key issues that any ombudsman or mediator must keep in mind, and including issues to do with the urgency, and also keeping in mind the existing procedures that may govern the institutions where we are doing the interventions. This is all very pertinent information. Probably during the question and answer session, I would invite you, Honorable Fatimata, probably to also shed a bit more light on whether in your work there is a means via which you can keep track of outcomes of your investigations in order to inform future interventions. How do you keep track of the learning experiences that you pick from your investigations so that you can better improve your interventions in later investigations? But that could probably be an issue that could be shed more light on during the question and answer session, once the next panelist has had a chance to speak. I thank you very much, Honorable Fatimata. We will now...
Merci à vous. Merci.
We will now hear from our next speaker. Our next speaker is Ms. Dominique Pierre, and Ms. Dominique Pierre is the director responsible for the Special Ombudsman Response Team at the Ombudsman Office in Ontario. She is a lawyer by profession and holds a master's degree in macro human resource planning, member of the Law Society of Ontario, and since joining the Ombudsman Ontario in 2006, she has worked as an early resolutions officer, an investigator, and a member of the Special Ombudsman Response Team prior to becoming the director in 2020. She has led a number of high-profile systemic investigations at Ombudsman in Ontario, including Oversight 911, an investigation into the government's oversight of complaints about emergency health services, the Code, an investigation into the use of excessive force against inmates and the Code of Silence against correctional staff, and Caught in the Act, an investigation into the expansion of police powers during the 2010 G20 summit in Toronto. Ms. Pierre, we look very We look forward to hearing from you. We can see that you have quite a wealth of experience, and we're looking forward to hearing from you about the guidelines for conducting successful investigations. You're very welcome to this webinar. Thank you. The floor is yours.
Thank you, David, and good morning. Good morning, everyone, and thank you to the AORC for inviting me to share our approaches to conducting successful investigations. Frankie's going to help me with the slides. Thank you, Frankie. So as David mentioned, I lead the team that conducts systemic investigations for the Ontario Ombudsman. And this morning, I'll be sharing some of the practical guidelines and principles that we follow to ensure that our investigations are successful. I have quite a bit to cover, so the pace will be brisk, but I'd be happy to answer any questions in the Q&A section. So first slide, please, Frankie, thank you. Framing your issue. The first principle that we follow relates to framing the issue for investigation. How you frame your issue is going to impact your resources, your timelines, and ultimately how much value your investigation adds. How you frame your issue will determine what evidence you need to collect and what findings and recommendations you make. You need to avoid overly broad or vague issues because these can take you down a rabbit hole of evidence and draw out your investigation unnecessarily. Your issues should be grounded in what can be investigated within your mandate. During an investigation, there are going to be lots of facts and issues that arise that might be very interesting, but may not fall squarely within your mandate. Don't get distracted by these. And don't duplicate investigative work. So often the issues that we investigate are topical. They might be headlining in the media or of significant public interest. You don't want to duplicate work that is planned or already underway by some other investigative body. The key is to add value by addressing issues not already under review. So it's important to know whether or not any other oversight bodies are looking at or planning to look at similar issues that might result in duplicated findings. For example, here in Ontario, we experience a significant number of COVID-related deaths among senior citizens in long-term care homes. At the Ontario Ombudsman, we're just wrapping up fieldwork on our investigation into the adequacy of the government's support to these long-term care homes during COVID. But the Auditor General also undertook a review of COVID in long-term care homes. The government had established a commission to conduct an inquiry into long-term care homes and COVID. And the Patient Ombudsman here in Ontario conducted a review of complaints about COVID. So we have to be very careful in framing our issue to ensure that we weren't duplicating work and that our findings and recommendations would be impactful. As my fellow panelist, Justice Rose Chizumula explained earlier, an important guideline relates to planning our investigations. But why plan? Your investigation plan is a roadmap. It's going to guide you through your investigative process. It acts as a checklist, it helps keep you focused, and it helps you to define your strategy. So for each investigation that we launch, a formal plan is drafted by the lead investigator with input from the rest of the investigative team. And the plan is approved by the Ombudsman. But what goes into a plan? The plan should cover things such as your rationale for the investigation. Everybody in your team should be on the same page as to why you're undertaking this. It should outline your jurisdiction, provide estimates for milestones and timelines for completion. It should identify sources of evidence, potential witnesses, and very importantly, your plan should identify potential challenges and obstacles that your team might face in conducting the investigation. Once you finish the plan, you're not going to file it away. An investigation plan is meant to be a guide to be used throughout your investigation. A good plan is a living document. It's flexible, responsive, and it needs to be periodically reviewed and updated. Next slide, please. Thank you. Another principle we rely on is outlining our investigative strategy. This is where the investigator is going to describe how they intend to organize and execute the fact-gathering process. The investigator is going to set out steps that they will take in the course of investigating the issue, including, for instance, providing notice. You need to consider when and how the organization you're investigating will be notified about your intent to investigate. Who do you have to issue the notice to? Does that notice have to be formal and written? You also need to consider your strategy for document requests. When will you request documents be And when will the request be sent? What part in your investigation? And who will you send it to? And most importantly, what documents are you going to ask for? I'll touch on this a little bit further down. As part of your strategy, you should consider whether you will publicly announce your investigation, for instance, by way of a press release. Publicly announcing investigations demonstrates transparency. But from an investigative perspective, it's also an opportunity to engage with the public and put out a call for witnesses, including potential complainants. Where you do publicly announce your investigation, your investigative strategy should indicate how incoming complaints are going to be triaged and managed. So in our investigation into delays at the Landlord and Tenant Board, we received more than 1,600 complaints after our press release was issued. This kind of influx of complaints can easily overwhelm an investigation team if they're not prepared. So what we do is we usually prepare guidelines in advance for intake staff who will be dealing with the complainants. And in these guidelines, we include samples of questions that should be asked of the complainants. We outline what information should be solicited from the complainants, and we are very clear with complainants about what we are and what we are not investigating. Another strategy that we use is the organizational briefing. This is a meeting between our investigative team and the organization under investigation at the very start of the investigation. These briefings are of benefit to both our office and the organization we're investigating. They're a good way to set the playing field and establish connections. This briefing session gives our team the opportunity to learn from the organization's staff and key officials about their processes and how things work. And it's also a good opportunity for us to answer questions that they might have about our processes and for us to educate them on our expectations. As part of your strategy, you should also consider if you're going to be contacting other jurisdictions to see how they deal or have dealt with the same issue. There's no need to reinvent the wheel, and quite often the problems that we investigate are not unique or new. So take a look at other jurisdictions that have dealt with the matter and see what are considered to be some of the recognized best practices. Frankie, I think you've gone one ahead. Could we go back 2 slides to sources of evidence? Thank you. So your investigation plan will also have an indication of your expected sources of evidence. This is something that we focus on quite intently in our office. This usually includes identifying the relevant and applicable laws, policies, and procedures, copies of relevant emails and correspondence, interviews, which interviews are a key source of evidence. Your plan should outline which government officials and employees, which complainants, and which stakeholders you plan to interview. Bear in mind that the list of interviews is not stagnant, and you're going to be updating it as your investigation progresses. You might find that people you originally had on the list are no longer relevant because they don't have information relevant to what you're looking at. You may find that you need to add others. So routinely review your investigation plan and your interview list. A wish list is a term that we use to refer to a written request for an organization under investigation to provide relevant documents. We issue this document request immediately after providing notice of our intent to investigate. As far as possible, you need to identify the individuals within the organization who you think are the custodians of responsive documents. You ask the organization to provide all the documents responsive to the issue under investigation. And we typically give 2 or 3 weeks to respond, depending on the volume of documents that we anticipate receiving. Our requests always have a clear deadline, although we do entertain written requests for extension. In drafting the wish list letter, we think it's important to be reasonable, practical, and realistic. And you need to consider the impact that your investigation and your request for documents will have on the organization's resources. So for instance, in our long-term care COVID investigation, we were asking the Ministry of Health and the Ministry of Long-Term Care for documents while both ministries were still battling the pandemic. So we had to work with them in terms of the timelines for receiving those documents. So you should be prepared to work with the organization to facilitate their response to the request. And for instance, you can agree to receive documents in batches. As they gather them, they can send them to you instead of waiting to have them all. This way, your investigation is not stalled and your investigators can continue the work. We also try as much as possible to use the same terminology used by the organization, so there's no confusion about what we're requesting. So for instance, here in Ontario, a lot of the government ministries refer to internal communication documents such as slide decks and briefing notes. So we use the same terminology in our wish list letter. We do not accept documents that are blacked out or redacted, except in very limited circumstances, such as solicitor-client privilege. The Ombudsman determines what is relevant. We don't leave that to the organization that we are investigating. If we have any concern that the information is being withheld, we address this swiftly with the head of the organization and/or their legal staff. And we usually include a request at the very end of our wish list letter for any other information and documentation relevant to our review, in the event that we haven't specifically asked for something that exists and would be of use to us. This puts the ball in the organization's court to provide it. So if down the line during the investigation, you realize or you discover that this document exists and you haven't received it, you can question them as to why they did not provide it. So you've issued your wish list letter and you need to plan how you're going to access and manage the information that you receive. So for many of us, gone are the days when an organization will deliver 40 bankers' boxes of documents. Over the last 2 years, many of our offices have seen a shift to electronic disclosure. So we really need to plan for this. What software and programs or format will the information be saved and provided in? Is this compatible with your systems and your software? You need to talk to the organization beforehand and let them know how you want to receive the information, including in what format. You need to determine internally what software and tech tools you will need to search and review the documents that you receive, and how many team members you're going to assign to this. In our long-term care investigation, we received over 1.3 million digital documents, and we had to access and search for lots of tools to help us to review and cut down on the number of documents that we had to look at. Don't forget your physical evidence, such as videos and photographs. You need to be prepared on how you will receive and preserve any physical evidence you require. And then there are always the document dumps. Document dumps occur when the organization under investigation delivers an immense number of documents, all of which might not be relevant to your investigation. Sometimes this is a deliberate tactic to hide information or impede your investigation. Sometimes it can be reflective of their willingness to cooperate and to send you everything they think is responsive to your request. But other times it might reflect a poorly drafted wish list letter by your team. So you really need to think carefully about what documents you need for your investigation and ask only for those. You can always go back and ask for other documents as your investigation progresses. You need to go back to your investigation plan and your issue when deciding what documents to request. Are those documents relevant to the issue under investigation? You should be specific about whose emails you want. Don't just ask for emails generally. As far as possible, identify the custodians of those emails. And you should provide clear date ranges for documents where possible. This is more readily done when your investigation is focused on a time-specific issue, such as an event. Like I mentioned, try to use language that organization uses to describe internal documents. Slide, please. Thank you. Another principle that we are guided by is to avoid issue creep. This is one of the greatest advantages of having an investigation plan and referring to it consistently. So issue creep occurs where you keep adding more issues and growing the scope of an investigation until it becomes unmanageable and chronically delayed. In order to avoid issue creep, we use the parking lot approach. So if an issue arises that is beyond the scope of the investigation, but we think it's worth exploring further, we park it and come back to it later after the investigation is completed. When planning for a successful investigation, we also pay close attention to any special considerations that might exist that we are aware of. You can't plan for every eventuality. Not planning for foreseeable special considerations could delay your investigation. So some of these might include managing expectations. The issues that you're investigating will not always be the same as the allegations put forward by a complainant. As the investigator, you decide the issues and the scope of the investigation, not the complainant. But you need to clearly communicate your issue so that there are no surprises at the end of your investigation. That's just procedural fairness. There are also moving targets, well, what we call moving targets. So often after an investigation is announced, an organization will suddenly start making changes, trying to preempt your findings and recommendations. So your team needs to keep abreast with what the organization is doing. Are they proactively making changes while your investigation is ongoing? Do these changes impact the issue being investigated? So when faced with a moving target, we typically get ongoing updates on the planned changes and timelines through periodic meetings with the organization. Another special consideration that one of my fellow panelists touched on is cooperation. Cooperation issues can be planned for, and these run the gamut from the organization not returning your calls or telling you they're too busy and short-staffed to gather the documents you've requested, outright refusing to provide documents, or insisting that lawyers be present during interviews, or that you put your questions in writing. So these types of responses to your investigation can significantly affect the progress, and you need to plan for them in your strategy. There might also be a fear of reprisal by some complainants. So it's important for your investigators to be aware of what protections exist for persons who provide information to your office during the course of an investigation. Is there a specific protection against reprisal for cooperating with you? You need to be able to clearly explain this to witnesses, including the limitations to those protections. And you should also consider, as a special consideration, whistleblowers, individuals from within the organization who come forward to provide evidence of wrongdoing. Whistleblowers can be valuable resources to your investigation, but they need to feel confident that their identity will be protected. Your plan needs to address how you're going to deal with any whistleblowers that might come forward. What strategies will you employ? Investigations are unpredictable. We all know this. You can't, like I said, you can't plan for every eventuality. But your investigation plan and your investigation itself need to be flexible, able to respond to challenges and changing landscapes. The key is to always revert to your investigation plan. Like I mentioned, it's a living document. The issue will always remain the same, but do emerging events or new information require you to tweak your strategy? So you've done your field work, you've conducted your interviews, you've gathered your evidence. What next? In our approach, as important as the field work are the recommendations. Recommendations should be SMART. Each recommendation should be specific, it should be numbered, and address a single specific issue or theme. Your recommendations should be measurable. You must be able to assess to what extent a recommendation has been implemented by the organization. Recommendations should be written in a manner that makes this assessment possible by your team. Recommendations should be achievable. They should be practical and capable of being operationalized. They should focus on what is to be done within reason. For instance, you're not going to recommend something that would be too capital intensive and likely not get funding approval. Recommendations should be results oriented. They should identify the corrected situation to be reached and not stipulate the specific acts required to correct the problem. At the Ontario Ombudsman, we leave it to the organization to determine the best way to operationalize our recommendations within their mandate, their budget, and their reality. So as an investigator, your focus is on assessing whether what has been done meets the spirit of your recommendation and addresses the issue that you identified. If you tell an organization exactly how to correct a problem that you identify, you run the risk of being blamed if that solution doesn't work. And your recommendations should be time-bound. They should specify when the implementation should be completed. Realistic timeframes for implementation will help organizations to set internal priorities, to take action, and to strengthen their accountability. Next slide, please. Last but not least, one of the key principles that guide our successful investigations is the follow-up. The success of an investigation is not determined only by the execution of the fieldwork, but also by how and when the recommendations are implemented. So follow-up is key, and it's an important phase in our process. Our reports include a specific recommendation outlining the manner and the frequency of progress reporting. We clearly state how often we want the organization to report on their progress, for example, every 3 months or 6 months. We also provide them with a template outlining the format for reporting so that there is consistency and we receive the information we need to assess their progress. In these progress reports, we want to see which recommendations have been addressed, specifically what steps they have taken to address them, and we want to see the timelines for the outstanding recommendations. Follow-up is usually the responsibility of the lead investigator, and the investigation file remains active until every recommendation is implemented. It is the Ombudsman who determines whether his recommendations have been implemented. But sometimes there can be differences of opinion on whether a recommendation has been fully implemented. There have been instances where the organization has reported full implementation of a specific recommendation, and we have disagreed. We discuss our expectations and we explore whether the action taken meets the spirit of our recommendations. So those are some of the guiding principles that we follow to ensure that our investigations are successful. I know that was quite a lot for you to take in, and I'd be happy to answer any questions you might have.
Thank you very much. Thank you very much, Ms. Dominique, for that presentation. Indeed, it has been quite a lot of information compacted into the 15 minutes time slot, and it's something that I'm sure has been quite beneficial. It has been quite beneficial to us as participants in this webinar, and we definitely look forward to hearing a bit more from you in the question and answer session. I particularly took note of some of the issues you raised with regard to keeping our investigations relevant, especially when it comes to the issue of moving targets. A lot of times there is always the risk of an investigation being done, but there is no focus on whether the institution in question is actually taking measures to correct what you're actually investigating. So I find that is also a very pertinent point to note. And the question of also keeping track of progress on the implementation of the recommendations is also a very big issue, because a lot of times we assume that when we have completed our investigations, that's the end of matters and we close the file. But if we do not follow these things up, a lot of times we find that the recommendations get shelved. So it's particularly helpful to hear from you that it's a good idea to have a recommendation on its own about some kind of a progress report to come from the institution. This, I think, would be quite helpful in ensuring that the reports and the investigations remain relevant and up to the situation. Thank you very much for that presentation. We shall now go into a question and answer session. Members, please note that we may not have time for all the questions to be accommodated in the limited time that we have, but I will do my best to present the questions that have been raised. Some of these questions might be contextual questions, and they may have to be answered by the panelists that are most knowledgeable about the context in which they're being raised. The first question that we received is to do with what is being done to protect whistleblowers. I think this came up during the first presentation. Unfortunately, our first panelist may not be able was not able to stay with us because she was not feeling very well. But if there is an opportunity for this question to be addressed, this is something to do with whistleblowers, what is being done to protect whistleblowers, and the contextual issue that raised there is the death of somebody called Babita Deodut. And the question was with regard to how are the ombudsman offices in Africa working to protect whistleblowers. I will go through the questions as I have them here, and I will then invite the panelists to respond to the questions that most relate to the context that they're able to address, that are most relevant to their presentations. The second question that I have here is, can issues of highly prominent business people be brought to the public protector? I believe this question was raised in the context that the business people are in the private sector. So I think somebody is inquiring whether these big business people who are involved in corruption, particularly in tendering, can be handled by the public protector and any other public institutions. The other question that I have here is the lack of control and mechanisms not at the core of high volume investigations? I believe that goes again towards probably the need for control and mechanisms and guidelines in hand.
You are muted, facilitator. Please unmute yourself.
So, okay, thank you for that. I was just going to I don't know at what point I got muted. I didn't. Is there something that, Frankie, can you bring me back into the context? What had I just said?
No, carry on. I think we did get your last word.
Okay.
Yeah.
The next question is, how do ombudsman offices effectively discharge the duties of exacting accountability within the context of a politically overbearing executive in African countries? So I believe the person who is asking this question wants to know how are ombudsman offices insulated from political interference. Next question is that, do you think that closer collaboration between the prosecutors and police will improve quality of investigations and evidence? This is in the context of investigations that are done in cases of criminal corruption and ultimately end up in court. And then we have a question, to what extent does technical evidence contribute effectively to ombudsman work? And I believe this question is more in the context of where the ombudsman has to intervene in highly technical areas and may have to rely on the involvement of experts to be able to provide the necessary evidence. And finally, what precautions and procedures are adopted for ensuring effective results where the investigation is highly technical? And that, I think, is related to the last question, where the ombudsman has to intervene in a field which is highly technical and may require the involvement of experts. Thank you very much. And I think probably we could start off with the last panelist, Ms. Dominique. I don't know whether there is any particular question that you feel falls squarely within what you've presented. If you do, please go ahead and respond.
David, of the questions that you highlighted there, not necessarily. A lot of them were based on the African context. So I would just be guessing at answers, which I wouldn't want to. But there was a question about whistleblowers and protection for whistleblowers. I know it was within the African context again, but I thought it might just be helpful if I shared how we deal with whistleblowers in the Ontario context. Because some of the approaches that we use can be applied. The protections available for whistleblowers depends on your jurisdiction. The constitutional legislation for the Ombudsman Office, for your Ombudsman Office, may itself talk about confidentiality and how you deal with confidentiality and confidential information. In the Ontario context, our investigations are conducted in private, and we take very, very seriously confidentiality of anybody, not just a whistleblower, but anybody who indicates to us during the course of an investigation that they have concerns about their identity being known. So in terms of getting information or soliciting information from whistleblowers, we talk to them about the confidentiality of our work. We talk to them, explain that we don't share their identity and that we take steps to keep their identity confidential. We take steps internally to keep confidentiality, maintain confidentiality during our investigations. We don't name these individuals in our emails or any other internal communications. We also talk to whistleblowers about how to contact us without exposing their relationship with us. For example, don't use your work telephones or your work email. Be mindful of call display when you're reaching out to us. This seems simple enough, but we have had so many cases where whistleblowers don't think about this and they contact our office from their government agency telephone or using their work email. We establish with the whistleblower where, when, and how we should make contact. And we make arrangements such as meeting after work hours and in neutral locations far removed from their place of work. And when we do, like I mentioned, when we do communicate among the investigating team with regard to a whistleblower, or we send confident correspondence to them, we do not include any identifiers. And those are just some of the strategies that we use in dealing with whistleblowers.
Thank you very much. Do you have anything to say about the issue of interventions where the subject matter may be highly technical? If the subject is to do with a particular field that probably may be outside the immediate knowledge of the Ombudsman Office, how would your office go about it? And do you have any particular procedures that you adopt in such situations?
You know, in Ontario, the Ombudsman has a very, very wide jurisdiction, not just over provincial government ministries, but hospitals, school boards, universities, municipalities. And I have to tell you, as you probably know, no two cases are alike, no two complaints are alike. So really, as investigators, we are placed in a situation where we have to become almost immediate experts on any situation that we're investigating. Sometimes that does mean that we rely on somebody, an expert who has that subject matter expertise and knowledge, but that they are treated just as a resource in our investigation. It is incumbent upon us to get up to scratch, get up to speed with whatever the technical issue is so that we can conduct a thorough and fair and objective investigation.
Okay, so in essence, you have to take the time to study the subject matter and become knowledgeable about it and see the best way to engage based on the knowledge that you will have picked from studying the background of the issue at hand.
Absolutely, David. But a big part of that is not just third party or external subject matter experts. It's also the very public servants who work using those processes that we are investigating. They are subject matter experts. So in interviewing the ministry officials and the ministry staff and the frontline staff who work and who use the processes that are subject to investigation, we are getting that expert information from them.
Thank you. Thank you very much. With regard to the questions in the African context, I would like to invite Honorable Fatimata probably to address us and speak to some of the questions which have been raised. At the end of her presentation, one issue in particular stood out for me. I would like to hear about whether there are any means via which the outcomes in investigations are tracked and subsequently analyzed in order to be able to create learning experiences and inform future investigations. And if there is any question that Honorable Fatimata also would feel she can answer from the questions that I've raised.
Merci pour...
Please go ahead. Thank you.
Oui, merci beaucoup. Je voudrais d'abord réagir par rapport à la protection de la source d'information avant de passer à l'autre question. Chez nous, dans notre bureau, nous avons la possibilité, nous avons même l'obligation de ne pas donner l'identité de nos donneurs d'alerte. Parce que tout simplement, la loi fondamentale qui nous a installés nous donne l'autorisation de nous saisir chaque fois que nous avons des motifs de croire qu'une personne ou qu'un groupe de personnes peut être lésé. Donc, même si nous recevons l'information au niveau d'un donneur d'alerte, le médiateur prend sur lui cette information et s'auto-saisit. Ça veut dire que l'enquête, l'investigation relève maintenant de sa propre initiative et par là, la source qui lui a donné l'information est protégée. Voilà déjà comment nous arrivons à contourner la première difficulté. Maintenant, concernant l'efficacité des ombudsman dans le contexte africain, c'est une question qui concerne évidemment tous les pays africains dans lesquels le statut du médiateur, s'il n'est pas bien protégé, effectivement, il est voué à connaître beaucoup de difficultés. Nous prenons notre propre cas. Lors de notre transition, il a été question à un moment de nous supprimer. Et tous les médiateurs de notre espace UEMOA, ils se sont donné la main pour faire un plaidoyer au niveau des gouvernements, de notre gouvernement, pour expliquer le bien fondé, l'utilité, le rôle, les fonctions, les attributions de l'institution aux nouvelles autorités. Et c'est d'autant plus difficile de nous supprimer parce que nous avons été constitutionnalisés. Notre constitution, donc, a reconnu l'importance de notre bureau et l'a donc inscrite dans la Constitution qui est la loi fondamentale. Et donc, en voulant supprimer le médiateur, ça veut dire qu'il faut d'abord supprimer la Constitution, ce qui n'est pas facile. On ne peut pas annuler une loi fondamentale comme ça. Et maintenant, ce que notre bureau donne comme conseil, c'est que tous les médiateurs africains, tous les bureaux de médiateurs soient prévus dans la Constitution. Ça va déjà les protéger et leur donner une plus grande valeur juridique pour pouvoir mener avec efficacité leur travail. Mais il faut aussi qu'en étant constitutionnalisé, que le médiateur en question sache qu'il a maintenant un grand rôle à jouer sur le plan de la démocratie et sur le plan de la défense des droits des citoyens. Donc, cette arme qui lui confère un pouvoir constitutionnel doit être pour lui un atout pour mener à bien ses investigations et jouer le rôle qu'on lui demande. Si la loi n'a pas prévu que le médiateur fasse la politique, il ne faut pas que ce médiateur entre en politique. Parce que chez nous, lorsque le médiateur est nommé, il faut un certain nombre de critères et, entre autres, il faut qu'il ne soit pas membre d'un parti politique ou même s'il est membre du parti politique, il faut qu'il démissionne avant l'entrée en fonction. Ceci pour dire que la loi aussi a prévu de protéger le médiateur. Si la loi a prévu de protéger le médiateur, la loi aussi lui impose un certain nombre de comportements pour le rendre crédible. Il y va de sa propre crédibilité, de son éthique et de sa personnalité. Voilà un peu ce que je peux dire concernant l'efficacité des ombudsman dans le contexte africain. Merci.
Thank you very much, Honorable Fatimata. I just have one final question for you, Ms. Dominique. There is a question about whether the Ontario Ombudsman has enforcement powers, because people are interested. People are interested in knowing what you do in terms of having uncooperative witnesses or the lack of cooperation in your investigations, and where there is also a lack of cooperation in terms of your follow-up when you're doing the follow-up and you find that there is lack of cooperation. In what then does the Ontario Ombudsman do?
So that's a two-parter, David. In terms of during the course of an investigation, well, in both parts, it comes down to us having conversations, educating them, listening to the questions and concerns that they have. So during the course of an investigation, if we are faced with a non-cooperative witness or non-cooperative organization, our first step is to discuss their concerns with us. What is the root cause of the lack of cooperation? What are their concerns? We address those. We can escalate if an organization refuses to provide documents. We can escalate it to a more senior person within the organization than the one we've been dealing with. The Ombudsman himself may reach out to a deputy minister in order to help us get cooperation in terms of the delivery of documents. But I think at a very basic level, it's having these conversations to explain our process and that it's of benefit to all parties and all people in the province, all Ontarians, that we look at a process, we identify the gaps, and we try to fix it. It'll benefit the organization and the organization's employees, and it will improve the service that organization provides to the general public. So those are the kinds of connections that we have. I think for us, it really does help that we take the time with individual witnesses and with organizations to keep the lines of communication open, not just with the immediate investigation, but that has a trickle-on effect for when we're investigating other ministries and other provincial government agencies. They see how we've dealt with other agencies, their counterpart agencies. They know what to expect from our process. They know we're open to answering questions, and they know that our approach is to resolve issues diplomatically at a first instance. Under our Ombudsman Act, the Ombudsman also has the ability to subpoena witnesses, but that is something that we seldom use because, again, we found it very beneficial and very effective to just have open conversations with witnesses and officials and organizations in order to get cooperation. In terms of the actual recommendations and what we do to make sure that they're implemented, it comes back to the relationships that we build during the course of the actual investigation, the field work. As soon as the Ombudsman issues a final report and investigation, either me or the lead investigator would call up the official that we connected with on the side of the organization, and we set up a meeting and we discuss with them. These are the recommendations. If you and your team discuss what your plan is for rollout of these, we can meet periodically to see how things are progressing. We have investigations where the directors on the ministry will reach out to us and say, you know what, we plan to implement recommendations in 3 phases. What do you think of this? We have instances where the government agencies reach out to us to ask us if we can provide insight to them, or if we can direct them in terms of where they can find information that might address some of the issues that they're dealing with. So we keep those lines of communication open. And that has helped us a great deal in terms of getting recommendations implemented.
Thank you very much for that insightful answer. And I think I hear from your response that the Ontario Ombudsman approach is
Lost you, David. We got on mute.
Sorry, I had an interruption. I'm saying that the Ontario Ombudsman takes a very stakeholder-based approach of engagement, and I tend to believe that it yields you more results because everybody tends to feel a lot more involved by the time you're concluding your investigations. And I think this is something which is very key and important in terms of achieving a sense of buy-in for all concerned, whether it's the complainants or the respondents. It's quite important for everybody to feel involved in reaching a tangible result. So I thank you very much for your insight on the topic, and I know that we would like to have a lot more questions, but we're running out of time. For the remainder of the questions, these questions will be put to the panelists, and the African Ombudsman Research Center will endeavor to provide the responses through the alternative channels to all the participants in this webinar. At this point in time, I'd like to thank the panelists very much for the very insightful presentations. We've all taken something useful from these presentations. It is always refreshing to hear experiences from the different contexts, from the different jurisdictions, because this all serves to, if I may use the term, cross-pollinate and help us to build on each of our approaches in our different contexts, because there's always something new to learn from each other. So I'm very grateful to the panelists who've taken their time to be with us here today in this webinar. I thank you very much. I thank also the participants for your very enthusiastic participation. The questions have been coming in quite regularly. We apologize that we've not been able to field all of them, but they'll be answered in due course. Dominique, is there something else you'd like to add?
That's it. Thank you, David.
Okay, I thank you very much. At this point in time, I would like to invite the Deputy Public Protector to come in and make her concluding remark.
Sorry, David. Due to time, I think we might have to bypass that. Already 6 minutes past 12, and we're aiming to finish at half past 11. So I think we might bypass that, and you just give your final word, and we'll thank the panelists and close.
All right. Thank you very much. I'd like to extend on behalf of all the participants in this webinar. I'd like to extend our thanks to the Africa Ombudsman Research Center for organizing this very important series of webinars. Like I said before, we are all learning something. There's always something to take home from these sessions. And I'd like to also thank the panelists once again for taking your time to share your insight and knowledge. And we look forward to continuing interactions with you over this very important subject of ombudsman work across the world. I'd like to thank the organizers, and also thank the panelists for your enthusiastic involvement. And at this point in time, I would say that thank you. And Frankie, with your permission, do I officially declare the webinar closed?
Yes, please.
Okay. At this point in time, I'd like to declare the webinar closed. Thank you very much.
Thank you so much. Thank you. Thank you to all the panelists. Thank you to Dominique. who will call you again, who will need you again. And thank you for all the other African Ombudsmen for being part of this. Thank you so much. Thank you. And this is the end. And Adrienne, we salute you. Thank you so much.
Oh, it's a pleasure. I've enjoyed every second. It was wonderful. Thank you.
Thank you so much.
you.
Thank you.
Thank
Thank
you.
you. Thank you. Thank you, Sylvie. And bye for now.
Thank
See you soon.
Bye.
Bye. Bye.
Bye.
Bye.